My name is Richard Epstein, director, along with Mario Rizzo of the Classic Liberal Institute. And we have Bo Heiden and Adam Mossoff, who head our team dealing with essential intellectual property of all sorts, kinds, and description. And we now have something of a mini tradition that's going of getting together large numbers of eminent scholars to talk about things that are of great importance to us and which work a kind of a synthesis, which I think is highly appropriate under a context like this. There's a real division of labor going on. As I look around this room, I see large numbers of people here who only could be described as distinguished historians, who know pretty much everything about anything that's relevant to the topic. And then there's some of us who are more frivolous in the way in which we think about this subject. And what we do is we write something which we grandly call some kind of economic theory or academic theory about how a patent system ought ideally to be structured. What we have here is a paper and a book, I have to say, which in many ways tries to bridge that particular gap. If there's anybody here who's read the whole thing from start to finish with all the footnotes, please raise your hand. If you do, I won't believe you, so don't raise your hand. But that's the whole point of this book. It's very rare that we could find anybody anywhere who's had such an enormous amount of devotion to the patent system and to its history, that they could put together this kind of stuff, which leads you to believe that as a resource tool for anybody who's doing other kind of work, this is perhaps the ideal place to come and to begin. And so what I want to do is to set the stage for the commentators and for Rob by just making one another questions about this as to how we think about it. And the first question one wants to ask is the question of periodicity. Why do we put the breaks where we put them? Does it make a big difference to the history if we start to put them somewhere else? I mean, I myself, for example, think in the modern period, there have been many ebbs and flows. We had a period of strong patent enforcement. We have the 1940s when things start to go weak. We get the Patent Reform Act of 1952. Then it goes down again, it goes up again, down again, and so forth. And so one of the things I would like to ask Rob and the commentators to explain is how do we explain these particular cycles? Is it something that takes place internal to the law as a matter of intellectual sentiment, or are there some external historical pressures that start to move things in one direction? And the second question that I would like to ask him as he starts to look through these materials is, can you identify the key trade-offs that have to be solved in each and every period? And then how they play out. So the most obvious one is if we give lots of protection to the guy who innovates, we're going to slow down the rate of imitation by people who could take great advantage of that stuff. And this leads to a big discussion about the scope of patents, the duration of patent, the area, essentially the choice of remedies with respect to patents and so forth. And so as we look at all of those variables, is there something that's going on which explains how the relative trade-offs we make differ across periods one way or another? One of the things that impresses me about this book, if you start looking at it, patent law is an area of genuine heavies. Story, Thornton, Rich, whatever it is you want to talk about. How much of this is a story of general social forces? How much of this is a story of few great men making a huge difference in the field, in force pressing their visions of the world on everything else? So if we kind of try to do this, the hope in a session like this can never be to try to distill every one of the sections and every one of the cases and every one of the arguments. So I think what we're interested in is sort of seeing if what we can do is to get a larger synoptic view of the particular subject, from which when we go back and read this book again, as we all will many times in many different ways, what we can do is essentially have a better sense of contextualization of how we should attack the individual periods. Well, I see my time is about over. I'm going to leave no time for Adam, who can now say a word or two on his own behalf. Adam?
Thank you, Richard. And really just wanted to thank everyone for joining us in this incredibly important roundtable that we are having to discuss and to celebrate Rob Burgess's incredibly important book, The American Patent Law: A Business and a Business and Economic History. It was just published this year. It has been a labor of love for Rob for many years in the production of it. We are looking forward to hearing his presentation on it shortly. And and then to having hearing, we have 3 commentators, fantastic commentators lined up. In order of their in order of their remarks, we will have Daniel Spolber from Northwestern University, Colleen Chen now at UC-Berkeley, and last but certainly not least, John Duffy from the University of Virginia, who will be providing commentary. Bo and I are run the Technology Innovation and Intellectual Property Program at the Classical Liberal Institute, that was founded by Richard Epstein and his good colleague Mario Rizzo, and we are very happy to continue our programming with this event. Bo, I don't know if you have any comments or if you just want to before we jump in, but please say something if you'd like.
No, I just want to welcome everyone. I think these book seminars are great, and this is a great opportunity to listen to all the hard work that Rob has put in. We're only going to give you 15 minutes, Rob, to sum all this up, so that's a challenge in itself. But thanks for leaving the book for the rest of us to read all the
Rob,
details.
that roughly means a decade per minute. A new measure of intellectual intensity. Okay, let's go.
Right. So, Rob, please take us away.
I just want to thank everybody for being part of this. If nothing else, this is going to save me some postage because I don't have to send Christmas cards now. I can say hi to everybody in the holiday season. Got a lot of different friends and colleagues from all kinds of times and places on here. So it's just personally, it's an honor for everybody to take time. You know, this extremely busy time of year, end of semester, holidays, everything going on. Or in the case of Dan Spolber, new grandchildren and stuff like that going on. So I just want to thank everybody for taking the time to do this. And especially Adam, who really was the person who pushed hard and did a lot of organizing, and also the CLI staff. Let me talk a little bit about this book that brings us together. It was a long time forming, the kind of project where you put stuff in a pile over the years and say, someday I'm going to get to that. And eventually I did. I have COVID partly to thank for it, for the time to do this. But in a way, I've been sort of working on this since the first day I started studying patents seriously with Dick Nelson at Columbia. That would be 1986, coming up on a long time ago. Because for me, you know, the economic history lens has always been extremely important. I've been a big consumer of it over the years, and only after so much time looking for references to the patent system in pretty much every paper on economic development and innovation policy that I could ever get, I built a pretty big pile of materials and said it's time for me to synthesize them. So that's where this came from. So why the focus on business and economic history? First of all, business history is sort of a faded term, but I think that it is distinct from economic history. And I was very interested in how business people use patents differently over time. I came to this wondering whether all the cases I've read over the years, whether I could put them into a coherent pattern and connect it up with the macroeconomic story, and then the story of how business organizations grew and changed over time. And that's pretty much, I think, the perspective that I take. Richard asked some excellent questions, not surprising at all. I think try to explain the periods that I chose to sort of give a little bit of a periodization, but also I want to address his very interesting question of sort of an internal versus external view, because I think that's a good question and important for this. So here are the periods that I broke out, and for people who study the patent system, I think you could contest some of these, especially the dividing lines, but probably in terms of most of the audience here, there would be some interest in each of the period on different topics. So the very limited federal state that we had at the origin of our country means that the patent system and the patent office in particular was literally one of the first administrative agencies. But because it was charged with an economic development function, and because it gave out property rights, and because it precedes what we think of as the administrative state, it's not often thought of as a proto-administrative agency. I think there's been some work in recent years, including some by Dan Spolber, Herb Hovenkamp, we've had some contributions on this early period, and Naomi Lamoureux has contributed. But I think the striking presence of an IP clause in the Constitution in a state that was designed to be quite minimalist has always struck me as important. I was just interested in how the very earliest days of the patent system, the administrative side, got going. So that's a focus there. I think for this group, maybe the 1820 to 1880 period would be very important, because I think it was probably the fulfillment of the best version of the patent system that we've had, in the sense that it was very democratic. It was open to everybody. It was not segregated by class. It was not prohibitive in terms of the cost of admission. Application fees were low. And essentially, it was, in the book, kind of a revelation. I knew that for many years, the patent office was part of the old Department of the Interior. But I never quite understood the connection between land patents and the selling of the U.S. public domain, and how the economic strategy of the patent system, the invention patent system, lined up with the tradition of land patents. If you research patents and you look at old cases, you're constantly coming across land patent cases. So for 25 years, I would say, no, I'm not interested in that. But over time, it occurred to me, why am I keep getting these hits? And what is it telling me about how people in the 19th century thought about economic development? And basically, I try to show that the strategy was very similar in terms of selling off fairly small individual-sized land plots for reasonable fees that Congress was always putting downward pressure on. It was very similar to the strategy of allowing patents for anybody who had a patentable invention, and the low application fee meshed with the low cost of land acquisition under the Land Act. Also, I think there are lessons from the land patent system about rent seeking, about speculators, and about how they were dealt with that's crucial to the patent system. Because to answer one of Richard's good questions, part of the cycle of the patent system, as you know and as you'll see, is that we have waves of rent-seeking, opportunistic litigation, especially when patents have been increased in value by the courts and by economic trends. And the patent system is, in a sense, always either in a cycle of building up value of patents or patent reform, because the high-value patents attract what comes to be perceived as excessive litigation. And so this, of course, puts the current patent troll phenomenon into perspective. I know Chris Beauchamp is on this call, and his work on the first patent reform movement and the first kind of rent-seeking concern, the big systematic patent reform of the 19th century. He's a specialist on that. And I learned a lot from his work and the work of other real historians who've laid the groundwork. The corporatization period, I think, has been studied, but mostly at the doctrinal level. So there's a lot of work, including by my colleague Catherine Fisk, on the growth of employer ownership of inventions and the transition from a more workshop and individual ownership regime to a corporate regime. But I was interested in looking at the legal changes, the economic changes, and used as my focal point there the old Continental Bag case and some of the inventions of the inventor Margaret Knight. So I'll try to get to that quickly. 1920 to 1982, as I say, in and out of the headlines. As most of you know, this was a period of increased antitrust enforcement where at times patents came under fire. But meanwhile, under the surface, some of the most famous tech-oriented young firms in the auto industry, electronics, et cetera, in some industrial fields, including Westinghouse, firms like that, they were also getting going. So the patents out of the headlines, which led to a lot of tech-oriented startups and new entry. I was interested in that because I saw that as a period where the antitrust enforcement was the big story on the front page, but the quiet work of the patent system was still going on. And then, of course, we're always interested in our current era. And I try to show a little bit of where the Federal Circuit came from, particularly concerned with Japan in the 80s and concerned with innovation, and really tried to show how the creation of the Federal Circuit was part of a wave of pro-innovation reform that grew out of a sense of stagnation in the 70s. And I think we are in the reaction period to that pro-patent era the early Federal Circuit, and the Federal Circuit itself has been a big part of the story post 1982. I know, at least on the invite list, we had former Judge O'Malley and former Judge Michel. So if they're listening, kudos to the court, and I hope I told your story accurately in those chapters. So here's a typical structure. These are the things I try to pull together, and I don't want to belabor that too much. It's the business organizations component that I'll stress in the very little time that I have here. Let me just give you some examples of how patents were used by businesses and how economic conditions changing over time and business strategy caused business to adapt essentially the patent instrument to different corporate strategies. That's probably the connective thread for the whole book, is how it's a pretty flexible policy instrument, a patent. And the flexibility, I think, is clear as you study the different ways patents have been used over time. And I think the balance between promoting innovation and then concern with rent seeking, the concern with excessive litigation, has always been an underlying theme. But as businesses adapt patents to different strategies, the patent reform theme, which is litigation oriented, can for me takes back seat. So for me, the use of patents by business people, most of which, of course, licensing, partnerships, et cetera, never end up in litigation. Sort of the private law of patents, you might say, the organizational foundation that patents can serve. That was interesting to me. So in the early days, many of you might have seen some of these old cases. I know Adam is extremely familiar with the old cases on patent shares. He's written about it. John Duffy knows about this. Colleen, anybody who studies patents, of course, Chris Beauchamp has written about this. But the use of shares of patents as an organizing vehicle for entrepreneurial activity is something that people have seen and talked about, and in Chris's case, called attention to. But I really wanted to tell the whole story and show how some of these business organizations worked and show how they are an example of how patents were adapted to the business context of the time. So in the early 19th century in particular, patent shares or pieces of patents were sold off as a ownership structure to structure partnerships and as a capital formation mechanism. And I go back now to my earlier point. Remember how thin and in a sense minimalist the federal structure was. And so I think there was also a kind of prestige from a federally granted property right. So you take a fairly moderate, kind of state presence, and you say, well, an individual right backed by the state and given and granted by the state was probably a good, wise use of the power that the federal government had inherently, because it put the ownership into individual hands, and it called on really just two aspects, of the state to make it go. There was the granting function, and we still have that now, and then of course there was the enforcement function. And I try to show how federal court enforcement was very crucial to some of the business uses of patents. Not only was it interstate, but the stronger legal remedies that you got with a patent gave them an advantage over trade secret licensing and some other kinds of organizations. And so the combination of a federal grant, which you could break up into pieces and sell off for individual ownership shares, together with the backing of the federal state, to me was the story of this early period. And to kind of answer Richard's question, I think the external forces to me were most important at this time. That is to say, the you might say the legal logic of patents was actually fairly flexible. And I think Richard will be pleased to hear that basic common law, private law instruments, basically contracts, partnerships, and then the infringement tort, that was really all that was needed, along with a federal grant, to get this kind of business model going. So some of the transactions were complicated, and I traced a couple through, like in this example. It just shows that, look, this is nothing like the volume of a stock market, but it did show that there was some liquidity in ownership shares, and that there was a market for owning a part of an invention-based enterprise, which was a quasi kind of minimalist, stock market or ownership share market. But of course, it wasn't regularized, and it ended up with some convoluted transactional structures like this one. And I document a number of these in the book, just to show liquidity and the dynamism of the system is really what I wanted to do. Another aspect of the patent share or fractional share arrangement that came in handy was the ability to break up patent rights by region. And anybody who studies the early patent cases, issues like patent exhaustion and issues like assignee estoppel and licensee estoppel, the early version of all those doctrines, you've come across lots of cases like this because the regional subdivision led to a lot of contractual conflict, as always happens with exclusive distributorships and dealership and any sort of exclusive regional rights. Cross-selling is a constant problem, always has been, right? So I used as an example of a regional organization, the famous Fairbanks Scale Company. They were the first ones to perfect the kind of scale where you pull your wagon onto a platform. You don't have to offload what's in it in order to weigh it. You weigh the wagon empty, then you put the cargo in, and then you weigh it. And these are very sensitive because obviously very large weights go on these platforms. And to get an accurate reading of the weight is non-trivial, but it was a clever mechanical solution, very classic 19th century kind of invention. We still use them today in different formats, right? So the way they broke this business down to me was interesting. And it has a lot to do with regional shipping costs. This in the era, of course, before extensive railroad coverage. So you look and see that in the closest region to their home base, which is up in St. Johnsbury, Vermont, they would ship entire scales, all made in the factory in St. Johnsbury. In the Middle Atlantic region, they would ship only the most crucial parts, typically highly machined metal parts, the weigh beam, and some of the other detailed mechanisms in the scale. And then the furthest region, really the furthest region that was economically reachable and developed at this time, there they just licensed bare patent rights. They just said to people, we'll share the blueprint with you, but it's too expensive for us to even ship metal parts all the way to Tennessee. So we'll license regional rights. You figure out how to make it under our design. You make it and sell it in your region, and all we get will be royalties. But the structure here, I think, was creative. And I don't think that we had a good picture of how these regional rights were rationalized and used to maximize profit. And a follow-on study that suggests itself, obviously, is how did these patterns change when the railroads came, when the telegraphs came? I talk about that transition, but I really don't talk that much about the mechanics of how it happened. And it's kind of an interesting topic, I think, laid out in the future. Obviously, at this time, common law patent-based organizations were essentially partnerships. So the contract is the fundamental form. Very interesting transitional period when trusts came into use. And anybody who studied the development of general corporation laws will recognize the era of the business trust. And I just show how it came to the patent world. And then the emergence of the corporate form, where patents became just another corporate asset that were folded into the general set of control rights and ownership rights in the corporate form. And obviously, to answer Richard's question about external influence, you might say the granularization and the modularization of technology, the fact that we had more and more specialization, and the fact that an individual patent could no longer cover an entire business enterprise, right? So patents stopped being coextensive with economic markets. They started to be identified more with components and features. And in that setting, an individual patent is not useful in most cases to organize a business. And that we see the emergence of the patent portfolio, which coincides with centralization of R&D and the creation of industrial R&D labs, which of course is related to the corporate ownership, the employer ownership issue, which I've studied in the past. The 19th century democratization of the IP system in the U.S., extremely well studied by Zarina Khan, and I learned a lot from her book, and I'm a big fan. Just to show out some of the points anybody could enter the patent system, and some of the inventions were quite prosaic. Some of them were quite modest, like this sap bucket. But in some work done by Ken Sokoloff, who was obviously a great contributor, and we miss him still, Ken did some work about how the Erie Canal promoted economic development. And so I was interested in this little farmer who patented a maple syrup collecting trough, really, who lived along the path of the Erie Canal and was a very modest farmer who thought he would try his hand at an invention. The corporatization story, I think we've seen, and the migration of rural labor into early industrial centers that we saw in New England has, of course, been recapitulated in China and other Asian countries. So that pattern of factory industrialization powered by rural labor, we've seen it in our country. The interesting thing is, out of that background came some interesting inventors, including Margaret Knight, who invented the folded paper bag, the grocery bag, the brown grocery bag that we still use today. And she was just an interesting person who began as a textile worker, made some inventions that improved safety, and then became a professional inventor. Some of her patents wound up in the hands of the Eastern paper bag company, and they were involved in the famous Continental paper bag case. I'm going to stop here because I'm probably going too long, and I hope we can cover some of the other material in questions. But what I wanted to say about this case was, in the era of corporatization, this case represented an important step. Because, as you know, anybody who knows patents knows that this case is often cited for the proposition, patents are strong property rights. The fact that you're not implementing a patented technology, the fact that the patent owner, in a sense, has their patent on a shelf and is not actively working it. That was the issue in the case. And when the Supreme Court said, hey, property's property, and there's no requirement in the statute that you use it in order to enforce it, so therefore we're going to find infringement despite the fact that the plaintiff does not actually implement or work the technology. That sounds like a straightforward holding, but if you are familiar with the historian J. Willard Hurst, the great monumental economic historian who studied the legal system, especially in the 20th century, late 19th and 20th century, his view was that the law tended to favor the active participant, the entrepreneur, that the law favored activity. And so the patent on the shelf aspect of this case, in a Hurstian frame, you might say, was controversial, right? Because it seemed to reward passive capital, passive speculators, which, according to Hurst, was not the preferred economic policy of the 19th century, right? But I think when you dig into it, you realize the court actually understood that the reason they didn't implement the patented technology is the patents were acquired in an acquisition, and the specific patented technology did not fit with the acquiring company's installed base. So basically, they bought this company for its technology, but also for its patent portfolio that would allow them to explore different options and maybe eventually change their manufacturing technology. But the Supreme Court was wise enough to say, you're an active company, Eastern, you may not be working this patent, but you have active R&D, you've been an innovator, so you are doing what the patent system is meant to do. And rather than test each patent for whether it's being worked or implemented, we're going to look at sort of the overall situation and say, yeah, these patent portfolios are in service of corporate R&D. That is overall contributing to innovation. So the working, non-working status of an individual patent is not so important. That was crucial to usher in the era of patent portfolios. And I'll stop here because today I think we're seeing maybe some of the business strategies that you might call portfolio centered. And there have been purchases and sales of patent portfolios of different sizes. But I think that early 20th century view that, hey, patents can serve a function when they're aggregated, and they can serve a general innovation promotion function, even if a specific patent isn't being worked. I think that was a sophisticated kind of view of the situation, and understood that this period of corporatization is going to require the legal system to shift. So to really go back to Richard's question about external versus internal, although, real historians can engage this maybe better than I can, but I've gotten the sense My son's a grad student in history at Chicago, and I've gotten the sense that the old-fashioned functionalist or sort of, dem sets, efficiency, trending stories are definitely out of favor in some branches of history. And I do think that the internal logic of patent law has had some impacts on the field, no question. It certainly has limited the types of things that can be patent, which itself has an influence. But overall, I would say you really can't tell the history of the patent system without talking about overall trends, larger trends, external forces. So it's a body of law that has a strong internal logic, but it is, and I think always has been, highly sensitive to changes in external circumstances, which of course explains the patent reform movement. If it was a strictly formalist system and if we just relied on the structure of the rules, there'd be no need for patent reform. We'd say, well, we're granting property rights, let the government get out of the way and all that. But the truth is, people have understood that there are parts of the patent system that at times can be abused, and that rent seeking based on patent claims is always a risk and a possibility. And so I think inherently it's an externally driven field, or at least it's highly sensitive to economic changes and development. So if there's a big, kind of contribution to the theoretical literature, it might be, hey, functionalism might not be trendy, but I don't think you can tell this story without functional explanations, without saying the judges were trying to pay attention to bigger trends. They were trying to make patent law relevant in new economic contexts. And I think largely the success of the patent system has been that judges have been willing. They've been willing to say, this part of the law is being abused. It is being used for non-innovation purposes, being used to capture other people's value. So we have to fix it. I think that's been a strong part of the patent system. Anyway, I could keep going. I hope we have a chance to talk about more contemporary things, but I'm going to try to stick mostly on time. I hope I did okay. So that's my piece on this. And I will stop the sharing.
Excellent. All right. In fact, you still have a couple minutes.
Yeah.
Well,
Why don't we just go? Why don't we
Okay.
just go? And I hope in the questions people can say if they want to talk about anything after 1910, well, we can.
Excellent. All right. Well, fantastic. Well, kicking off our series of commentators today, we have Dan Spalber, and I just want to second Rob's congratulations on the mitzvah of the arrival of another grandchild today for him. So thank you, and it's wonderful to have you, Dan. So you may start with your comments.
Thanks very much, Adam, and thanks, Adam, Bo, and Richard for inviting me and for introducing me to this very interesting and marvelous book. I greatly enjoyed reading your book, Rob. It's really a great achievement, and I want to say a few things about it and maybe a small quibble at the end, but I want to tell you I enjoyed reading it very much. I learned a lot throughout, almost continually. I saw things I didn't know, and I learned a lot from it. Rob, you tell us at the beginning that it's your goal to write what at least French historians call l'histoire de la longue durée, which I translate into economic terms as history in the long run. But in history, la longue durée essentially means, or early on, it meant a step away from event-based history that emphasized key battles or succession of kings and so on, but rather sought to put history in the context of the long run, focusing on maybe a geographic area, but bringing in daily life in a way, bringing in economics and other institutions. And so I would say that Rob achieves this goal. This is certainly a history in the long run. It's in a geographic context, of course, the United States, but it's also in the context of economics and business history, and as well legal history. I want to compliment Rob on careful reading of various patent cases to get ideas from it, and also looking at specific patents and technological changes, and looking at the companies and their involvement. And that gives a consistent read throughout of this historical context. Now the French historian Fernand Braudel is credited with Histoire de la longue durée. Of course, Karl Marx was preceded him with this sweeping view of long-term history, but he was more of a determinist. He thought it was all predictable. This is not that. This is the better side of all that tries to look at the economic context without any determinism. And so I compliment you on achieving what is really a difficult thing to do. The broad sweep begins in 1790 and takes us all the way to the present time. So that's a difficult thing to do. And as Rob points out, there are specific histories that look at pieces of the overall sweep here. But this is an attempt to bring it all together. Rob says, I lay out the general economic trends that formed the background to invention and technological development. So I believe that Rob does that. He shows the general economic trends and puts it in the context of technological change. And I appreciate that a lot. I like the notion of what is technology and what is innovation, that those things go together, that we tend to focus on innovation, in other words, technological change, but without putting it in the context of what is the technology itself that's in the process of changing. So the book divides things into 5 eras, and I'll say a word about each one, if you don't mind. But it's interesting that they correspond to important technological changes. The post-revolutionary period, or the founding era, corresponds primarily to agriculture. The United States economy was founded on agriculture, and that was key at the time. The Jacksonian era, 1820 to 1880, is the period of, as Rob points out, the period of early industrialization, the shift from farm to the beginnings of the shift from farm to factory. And of course, the corporatization era, also called the progressive era, is large-scale industry, and is reminiscent of works in business history, such as Alfred D. Chandler, as you mentioned, that starts to look at, mass production and then later mass marketing and so on. Then the era of what you called the in and out of the headlines. I might call it the bad news for patents era, if that's probably unfair, but I think that's what you were saying with the in and out of the headlines. Maybe the most important thing in that era, we could point to electrification and so on. This would be the period 1921 to 1982, but it's really the rise of the scientific revolution and the systematic development of innovation and technological change. But finally, the modern era, the dominance of scientific and technological progress. I really enjoyed, I'd say I enjoyed all the sections, but if I had to pick one, I enjoyed the founding era the most, because here you lay out the notion of patents as a kind of low-cost instrument of economic development to boost productivity. And of course, I like the analogy to land grants, property rights, and intellectual creation and land grants here you say that individual owners were already a bit of a myth. And so I thought that was a really interesting discussion. And you emphasize patents as market franchises rather than simply technology-based. And I found that IP rights were viewed as standalone in this period rather than as part of something that's combined or necessarily commercialized. But on the other hand, you say that private ordering used patents in many different ways. And I found that discussion of great interest. And also the role of patents in the decentralization and democratization, the decentralization of government power. So the following, the Jacksonian era, as you call it, 1820 to 1880, is a period of rapid industrialization and economic growth. And you would expect that patents play a role here. And I like the discussion of the factory machine shop. And you mentioned it just now in your remarks, the in detail case study of the Fairbanks platform, also very interesting and illuminating, putting patents and patent law in the context of these things. And also the effect of the commercialization of IP on the formation of the firm. As you know, I'm very interested in establishment and development of the theory of the firm. I've written a lot about that. And I was interested in the notion of commercialization of IP as being key or foundational for the establishment of the firm. So I enjoyed that discussion. I also found it interesting that the corporation, the notion that the corporation begins to displace patents and patent-based partnerships as a form of organization of the business enterprise. And you begin to address the patent portfolio. So there's an early appearance of the portfolio. Then you turn to the corporatization era, 1880 to 1920. This is particularly interesting to me, the corporate R&D, the vertical integration of R&D and production. Just a historical note. So it's, I think, been widely noticed, or at least I've noticed that Schumpeter, as a young man, believed that there was no hope for incumbent firms to innovate, and that the only hope was an entrepreneur engaging in creative destruction and knocking out the incumbent firm. But later in capitalism, socialism, and democracy, in that period, the older Schumpeter comes to the realization that there's vertical integration in terms of corporate R&D, and that the corporation is innovative. But he has the young Schumpeterian view around the beginning of the 20th century, but the older view that the corporation is vertically integrated in R&D is in the 40s. So, but you have all this happening in 1880 to 1920, which is, I think, very important to point out. And I guess Schumpeter missed it, but he got it later. Within a few decades after that, he came to the realization that the innovation was happening within the corporation. I'm particularly interested in that discussion because the modern era, say 1980 to the present, when we get to that later, is the era of decentralization, de-vertical integration, what people have taken to calling today open innovation, where you have less and less and less vertical integration of the firm. Think of GM and Ford pushing out their parts divisions around the time of their bankruptcies. And at the same time that you have the de-vertical integration of firms or flattening of firms, you have the pushing out not just of the divisions, but of R&D. So this corporation vertical integration that you're talking about in 1880 to 1920 in the modern era, I think, is reversed. Today we have open R&D where companies outsource or source or purchase or supply R&D to others. So it's a reversal of today, a reversal of what you were talking about in the corporatization era. There are corporations today, but they're very flat, and they have what's called an ecosystem now of inventions and innovations that provide these to the firms. So here you say, look, the patent now is part of a broader portfolio owned by the firm, but patents are not the core assets of firms now in the 1880 to 1920 because of the rise of capital assets, in other words, plant and equipment. This is the opposite, I would argue, as to today, where we see plant and equipment, some say, being less than 15% of the value of the S&P 500. So again, a reversal. I enjoyed the review of AT&T and GE development, and you do point out that in this period, patents are useful to entrepreneurs. And here you see the young Schumpeterian view supported at least by the entrepreneurs being helped by patents. Then we enter into what I call the not so good for patents era. You may quibble with that, that's fine. 1921 to 1982. And you say in academia, especially antitrust, there was a relentless association of patents with monopolization. I enjoyed that sentence a lot. And I would say, we're talking about 1921 to 1982, this maybe culminates in Arrow's classic 1962 paper, which I believe takes up this idea of patents as monopoly, unfortunately, and repeats it in the economics literature. And that becomes the standard assumption in the economics literature, unfortunately and incorrectly, in my view. But it has its roots, I see now, in the 1921 to 1982 antitrust era that you highlight. And yet, despite this, patenting increased and continued, as you point out, and so did innovation. So despite the bad mouthing of patents, patents are very important in this period and continue to increase. All right, I'm wrapping up. We come to the Federal Circuit area, 1983 to the present. Everything is there: computers, biotechnology, the Federal Circuit, the reinvigoration of patent law that you talk about. I enjoyed that very much. And now a little bit of a quibble. During the Federal Circuit era, I think you do a good job of introducing SEP's FRAND and so on. However, my quibble is that a little bit more could be said about standards organization, standard essential patents, FRAND, and so on. And again, NPEs, I get upset every time I see the word trolls. I understand that you're drawing an analogy to patent sharks, but I'm upset by the terminology. And you point out correctly that it was changed more recently. But I was unsatisfied. I thought that the book is very balanced, but the discussion of technology standards and FRAND doesn't make a sufficient connection with the modern literature that details the contemporary history and events surrounding more than 1,000 international standards organizations, which have themselves. Now, of course, time is short. The book has a grand sweep, but I would have liked to see just a hint that there are standards organizations, and the technology standards have become the organizing principle for many patent portfolios and commercialization of patents. Okay, that's a small quibble. The book is fantastic. I think you do a great job of introducing the contemporary era. I think you do a great job of covering the entire sweep from 1790 to the present. As I say, I learned at every stage, I learned a lot of stuff that I did not know, but also stuff that was really interesting and important. It wasn't just, hey, I didn't know this and it's not important. It was, hey, I didn't know this, but it's really important. And so I enjoyed the book a lot. And I think that you've issued a challenge to historians here that when we approach again patents and technological change, it would have to start from this as a beginning. And so it's a landmark work. So thanks very much for writing it. Congratulations. And I wish you all the best with it.
Thank you, Dan. Continue the great commentary.
I want to start out with the biggest of the big picture strengths of this book. And the biggest strength, I think, is that it addresses something that I've always seen as a terrible weakness in law school in general. We say that we engage in a case study method in law school, but we don't. You know, we engage in an appellate opinion study method in law school, which is a very, very small piece of the case. You'd at least need to read the briefs, all the briefs, if you wanted to understand the case that you're reading about. And really, if you want to understand the case, you'd want to read the whole record. And then if you really, really wanted to understand, you know, have a deep understanding of what was going on, you need to know all the historical and political context. Well, there's a reason that, you know, we don't do that. One, it's impossible in a law school classroom, and we don't even do that often in our scholarship. So a standard law review that can get very good publication will be, this case said this, and the other case said that, and here's how the case is developed. The reason we don't do the thing that Rob has done in this book is it's a lot of hard work. It's an extraordinary amount of hard work to do this, and it takes quite a scope of learning about not just the law, but about lots of other things too, in order to take this comprehensive approach to a field and to the development of law and legal controversies and the resolution of those legal controversies. That is an incredible strength of this book. And it's something that I think we as a profession, you know, be it as, you know, legal scholars, we have to think about doing more. The second thing I'd say is one reason Rob is really particularly suited for this, especially for a business history of this, is because I know he teaches contract law. And contract law is a natural jumping off point into this area. I don't teach contract law. I teach torts as my first year course, which actually is weirdly enough a jumping off point to public law, because torts is the sort of social contract, the implicit social contract that sort of is required of all of us. And it's the entry gate into teaching about administrative law and, you know, health and safety regulation that's imposed on us. But Rob teaches contract law, which is the jumping off point of private ordering. And, you know, you can see that in many, many ways. You know, when Rob really goes down a rabbit hole, it's often about, you know, what are the contracts like? What is the private ordering about? And I think that's, you know, just brilliant if you want to understand this whole other aspect of patent law. Patent law has a public law aspect of it, which I'm deeply interested in it. But then, and, you know, this is obviously one of the biggest themes of the book, it creates this private law. And the public law structures often develop in tandem with the private law structures. And there's a reaction on both sides that the public law might have some flaw or some bug in it or some restriction, and the private law will respond to that. And so also the other way, there can be public law reactions to the development of private law. And we'll get to more specifics on that in just a minute. And then the other reason Rob is great about is to do this is that Rob has a deep appreciation of economic principles, which if you want to talk about business and do a business history, you really absolutely not only need to know and be sophisticated about private ordering and contract law and things like that and corporate law, but you really need to understand economics or you'll just be at sea. There'll be no good poll stars for you. And I think Rob is correct to say, you know, two things that you can hold on to throughout this economic history is rent-seeking and incentives as important things. And I just have one comment on that. And, you know, this is, I think, implicit in the book, but I would say that as a former student of physics, physicists are always in the modern era looking for a grand unified theory, right? We don't have two forces, we have one force, right? We don't just have electricity and magnetism, we have electromagnetism. Now in the modern era, it's the electroweak force, right? And I think one thing about rent-seeking and incentives is they are the same thing. They're the exact same thing. And rent-seeking is when we give incentives that wind up being for unproductive conduct. So you can, for example, with patents in the Old English era, before they had the statute of monopolies, people said, well, here's how I can get a patent, which was just an open letter from the king that gave you exclusive economic rights. I can be a really good courtier and sort of, you know, play up to the king and be somebody who hangs around court all the time and does things like that. That's bad rent seeking, isn't it? It's an incentive system, but it's an incentive system that gives us incentives to do things that are not socially productive. The nice thing about the patent system is it gives incentives and it forces rent seeking of a certain kind. You're always trying to get the technology a little faster. That's a form of rent seeking. You actually dissipate rents in that way, because by moving the technology earlier in time, you're actually going to dedicate it earlier you're going to dedicate your technology to the public domain earlier. So it's a form of rent seeking that we incentivize that winds up helping the public, because a race to invent is a race to dedicate something to the public domain. And I think that is really one of the brilliant structural features of the patent system. But Rob is actually, you know, once you divide that unified force of rent seeking and say there's good rent seeking and there's bad rent seeking, we call the good rent seeking incentives to innovate, and the bad rent seeking we just call rent seeking. And once you make that division, it is absolutely true that throughout the history of patent system, you have to take into account how the system is fostering either good or bad rent seeking. And that, I think, is a theme that goes throughout the book. And that, of course, grows out of Rob's deep appreciation for economic principles. The second part of my little remarks here, and by the way, Adam, maybe give me what am I, halfway through? I'm not so sure where I am in my minutes. I guess I'm in Colleen's minutes, so I get to go to 2:10. Is that right? Okay, so 2:10. So I'll be a little bit faster here. Middle sort of themes that I see in this is one I really liked, as you know, Dan Spalber said, I really like the land patent stuff too. So, you know, I always think when you're giving comments to an author, you should tell an author when they're hitting it out of the park. I like the land patents. I think it's something that it speaks to me as an administrative lawyer, somebody interested in the public law. Obviously, it speaks to Rob in the private law dimension. I actually think there's one thing here that the reason the unity between these two systems is so important is because it I think points out something you hear a lot in the modern era, especially from people who are somewhat anti-patent, is they say, oh, patents aren't important to our business. We're business people, we're doing high tech, and we're not really interested in patents. And, you know, they probably would say the same thing about land rights. You know, they'd be like, oh, you know, we're doing a business and we're going to do this, that, and the other. And we don't need land, you know. It's like, oh, really? You don't need land. What are you going to do about your business? Oh, we'll just rent something. And you're like, well, wait a minute here. If you're going to rent something, it's because we have property rights that you're able to rent something. And if you say, well, we'll just do home office, we'll do virtual. Well, the people who live in their home office are either going to own their home or they're going to be renting their home. You need those property rights as a sort of invisible superstructure, a sort of often taken for granted superstructure that people then, I think, don't realize the incredible importance that the rights have. I think that's harder to do with patents. I think there's only, a sort of certain set of academics who say, well, if you're in high tech, you don't really have to care about patent rights. I think that's a minority position, I think. But I do think that the analogy to land patents teaches us something deep about some things are nearly invisible to the business people. They just assume they're true, but that doesn't mean they're unimportant. One thing that Rob is really great at, and this is why I've been extremely fortunate to be a co-author with him, is he's got a great way of framing things. Late in the book, you have this line, Rob, where you say, people talk a lot about transaction costs, but not a lot about transaction capabilities. That's one I'm just going to remember forever, about lawyers, about the legal system in general, and about private ordering, right? Which is the dominant theme of your book, or one of the dominant themes of your book. I mean, boy, what a turn of phrase that is. I've heard people talk about, transaction costs, and people push back on that, but that is a brilliant, brilliant turn of phrase that encapsulates, it's not just a cheap turn of phrase, it encapsulates a really good idea really well. So you should trademark that one, in another area of intellectual property, I think. So that's really good. And I think that also is, the other theme that, the idea that there can be private reactions to public law. I think that is a really good jumping off point for that idea, that you can have, if there's a weakness, if patent rights are too big or too small in size, you can have private reactions to that. Contract rights can deal with that problem. You can either chop up patents, as they did in the earlier era, or you can maybe put them together in portfolios. And that leads to my final sort of middle tier point, which is, the world has shifted. And I think this is just, sometimes you need a standard source to say this, but the world has shifted from a patent to a patents. I tell my students that all the time. Now I'll just refer to your book as good authority for that. I think that's really important. Like the Wright brothers had a patent. They would just be crushed today if they had one patent. It turned out to be a pretty strong patent, had some bugs, but it turned out in that era to be sort of hospitably interpreted. But today you don't want that. You want a bunch of patents. You want a portfolio. And I think you give some really great reasons for that. And I don't know, I only have maybe a minute more. So I'll say I wanted to give 3 examples. That's always a magic number, to give 3 really great examples. You already talked about franchising, so I'm not going to talk about that. I think Continental Paper Bag really taught me something about the shift towards corporatization and the shift towards portfolios. I guess I know about that case. I know what its holding is, but I think I've not really done a deep dive on just how important it is as a watershed case that allows this change towards portfolio approach to patents. I really think that's an extreme strength of this book. Another example later in the book is the Bayh-Dole. You wanted to talk, some of your commentators, to bring us into the 20th century. Bayh-Dole is really great. I mean, like the way you connect that then to university patenting, which then leads to some of our current controversies, right? 101 and also 112 controversies, sort of the scope of patenting and pushing out the frontiers of patentable subject matter. Some of that is because of Bayh-Dole, oddly enough, that those are reactions to the public law, that if you incentivize universities to get more patents, well, they're going to do it. And those patents might look a lot different than what IBM gets in its patent portfolio. So I thought that was really good. Trolls and evergreening, that's a modern topic that you put together, and you suggest quality is the solution. I think that's right. I think I'm running out of time right now, so I think it's really good to talk about those 2 things. I would just, at least with respect to patent evergreening, I think that perhaps patent evergreening is not as much a patent problem as a regulatory problem, that the problem lies outside the patent system. It lies with another regulatory system that we know about, but that is actually blocking the kind of positive rent seeking that we normally rely on the patent system to do. And that's the FDA system and and a lot of the complexity of that legal system. Trolls, I think you're right that, you know, you got to worry about that. But I see I'm out of time. I love the book, Rob. It just sort of is a highlight of your extreme strengths as a scholar and your range as a scholar. I hope I did it a little bit of justice in my comments.
Thank you, John. All right, and Colleen, who congratulations as well on joining UC-Berkeley and now being a direct and immediate colleague with Rob, for which we could all be very jealous. So take us away.
Thank you so much. Can everybody hear me now? Hopefully, great. So it's my pleasure to be here today and to be able to talk about Rob's book. But I first want to start by talking about Rob as a person and a writer that I think we are all so fortunate to have in our community. So I just want to say 4 things that I appreciate about Rob as a writer. And the first thing is that I think, you know, he's not only a careful and broad writer, but he's a careful, broad, and voracious reader. So I think one service he does to us, if you look at his footnotes, they're extremely capacious. They're covering so many different fields. And he sets an example by reflecting on a conversation within the community, but also beyond it with respect to people and thinkers beyond patent law. And in any topic, you know, he might write one sentence above the line, but below the line, you've got all the references that you want to go to kind of get to dig deeper. So that's a real service to the community, and I'm grateful to him for that. I think what's really important, just striking in reading this book, is that how Rob really transcends the tribes we tend to think about in patent law. And that's because of what John just mentioned. He does the work and he synthesizes it all, and he does it so beautifully. And so even if he's commenting on things that others have commented on, I want to read, you know, every single word, because his take is going to be considered. It's going to reflect many dimensions, and it's going to be fair. And that's, I think, why his work is so respected by all. I think, you know, kind of connected to this, as he's talked about the evolution of patent law, like patent law, his opinions have also evolved over time. They aren't rigid, they're not predictable. And again, I think that this, I'll talk again about a specific example later. You know, in many cases, Rob is, you know, as much of a giant as he is in the field, you know, and I'll talk a little bit about some of the different accomplishments. He has quietly had a big role in many of the changes we've seen in the patent system, and his ability to kind of have you know, kind of a role, you know, in creating PTAB, frankly, and getting to IPR and, you know, where we are right now. But then to comment and step back is something that I think is pretty unusual. And, you know, because he's had this foundational role in shaping the patent system, but then commenting on it has given him a very unique purview, but one that evolves and is not rigid, much like the theme of his book. And I finally just want to call out his range as an academician. They were talking about the 1790s 2 weeks ago. He gave a whole conference on AI and patents, and he's really doing the very, I would say, fresh and important thinking on how AI is going to affect patent law. And I'm just really proud to be his colleague. And I think I feel, I understand what a privilege that is. So I do also now, I want to put some slides up just to kind of give me a little bit of information that I want to share. And I do want to, just like his book does, situate this achievement among his others. And I think it's just, you know, we kind of take it for granted. Rob Murgis, you know, is sort of the leading person in patent law, but I just want to kind of state what this looks like in our community. If you didn't learn from his book, you're probably teaching from it. In my case, both are true. His book with John Duffy was the first patent law academic book, and opened up the field really to all of us as patent law professors. It gave us an excellent book to teach from, to learn from, and continues to be really the gold standard. Not only that, but Rob happens to write, you know, articles and books, and he is, I would say, the top rated sort of pure patent scholar among this whole community. And many of you are in the audience are on this list as well. It's you know, the fact that he's able to command such a esteemed group of people and convene them is really a testament, again, to his influence. We've learned so much from him, not only in the classroom, but also in our writing and everything else. He's also, you know, the founder of the leading tech law program in the country. which has been at the top for a long time. I benefited from it as a student, and now I think, again, there's just a lot of generosity in that center to continue doing programs. I'm going to have to leave this program after this to go help run another program that BCLT is putting on with Stanford. And of course, his landmark work that really made a lot of us rethink and center what is the purpose of intellectual property. And I remember when Dave Schwartz was giving him an award at PatCon a couple of years ago to talk about somebody who's so invested in patent law, actually just starting from the fundamentals again and asking, like, how can we justify this? I think that shows a lot of intellectual courage and really sets an example for how we should engage this material. All right, so finally, let's get to the book itself. American patent law, the topic for today. And I'm going to kind of keep it pretty short because I'm very interested in the rest of this group. It's such an incredible group. So I'm going to talk about 7 things that I really liked and 1 idea or intervention. So we'll just start with the first one, which is I really enjoyed how he engaged in first principle thinking. What is the patent system, and what is, what are patents? Why were they created? And again, he talks about small grants of government power to be dispersed to individuals. And the purpose, again, of the founders was really to allow these individuals to raise money to create, improve, and implement new invention. And I think this is a very durable definition in thinking about patents. And I think it really underscores that patents are a means to the end. Like land, they are small parcels that are consciously intended to alleviate, in that case, the shortage of labor, but to induce effort, right? And I think John's work has been so fundamental in terms of the inducement theory of patent law. It's really about inducing effort that would not have otherwise been there, whether it's effort in actually coming up with the invention, or it's effort in commercializing it and doing all the hard work of finding the partners and getting the commercialization strategy worked out. These are really hard things. And without that kind of protection, people are not going to engage in them as much. So easing this pathway to the practice of new inventions. And I would just say this first principle thinking is not easy for us as academics, right? We kind of get into patent law. And I remember when I worked in government, often I'd write memos and people would say, this is far too dense, like simplify it. So I think this ability to go back to first principles and really evaluate the system with this fresh pair of eyes is very, very rare, and something that we can all strive for. Because I do think the courts and policymakers are always returning to this calculus. And the ability to go back to first principles. I think kind of in accordance with this, his kind of ability to think about the patents, what they are, how they come across, right? We know from the Oil States case that patents are public law, public franchises, right? The federal government grants the rights, and the economic power the rights confer must be policed and regulated carefully, as he talks about. Which is classic public law material. If you hang out with the law and political economy folks, or for Katerina Pastor, she goes further, and she actually has a whole section in her book about the code of capital, the legal code of capital, about patent law, about how the patent law, the different contours of it, its regulations really shape its role in the market. But I think the duality is what is really true is that patents themselves are private law instruments. They're private instruments and assets that companies use, that individuals use to negotiate with each other and do all sorts of things with them, right? And he talks all about kind of different uses of patents. So I think capturing and embracing this duality is really important. I know he's doing some important work on private law more generally, and I'm looking forward to seeing how that intersects with some of his work here. But again, trying to really hold this duality and to acknowledge it in what we do, because sometimes we are really talking past each other in the community, right? We say, well, no, patents are really supposed to be for this. And then when companies are actually trying to make decisions and trying to make huge investments, no, they are treating it in a private law way. So just to be able to kind of chew gum and walk at the same time is something that Rob can do. And I think he encourages us all with his writing to really be able to do. Similarly, I think, capturing the kind of essential question for many policymakers is thinking about this difference between rent seeking and rent that the patent system creates, and the beneficial incentive on the other side. And I think this is something we take for granted, but I think by him kind of acknowledging the different episodes in history, he's talked about what Chris has written about and others, the more recent episodes of patent assertion entities. I think he normalizes this idea that there is this balance that's going to be out of balance sometimes, and sometimes it's going to be far too much on one side, and then it will swing to the other side. But this is natural tension, and it's part of getting and calibrating the system at all the time. And so I think just acknowledging the dynamic nature of the system and that this distinction is important to try to balance is also important. And he does that kind of throughout the history of the system. And that, I think, goes to this idea of the protean patent, right? And that that the courts and the patent office have adapted what the patent system is to what was needed at the time. And the Cars song, comes to mind about what was needed at the time, and how really there is this democratic tradition, because as much as patent scholars or patent empiricists, myself and others included, or law and econ folks say, well, there's an optimal patent. It's really only optimal under a certain context in a certain time for a certain need, right? We have to understand that we're part of a larger democratic system. And so if public opinion and public sentiment is expressed in a certain way, unless we change it, that is going to shape how the court and others are going to also move and try to recalibrate. And so again, I think what is also great about Rob, as I mentioned earlier, is his own co-evolution in his opinions about the patent system. So to talk about opposition, he was involved at the very beginning with thinking about whether or not we needed an opposition-like system in the United States, because we knew reexamination, reissue weren't really working for post-grant reexamination. So he was involved at the very start, doing the very fundamental work to kind of start the thinking about getting to a point where we might have an inter-parties review institution or process. Fast forward, his work was successful in terms of what he's kind of kicked off, and then others followed and decided to incorporate IPRs in other post-grant proceedings as part of AIA. And I've really enjoyed watching him evolve his opinion on how the PTOB is doing, right? And so I've heard him say, let's give it some time, and also let's leave it alone. Let's do what we need to do. But then when you go to the end of the book, he talks about how there may need to be a need for there to be some check on the number of times somebody's patent can be contested. And so he's not rigid. He's not like, well, I came up with this idea, I'm going to defend it. He's evolving his opinions as we go along. And I wish more people in the patent academy and the patent system were generally, I would say the academy, I think we are more flexible, but in the system in general, people tend to get into their tribes. And I really appreciate that about him and the example he sets through his work. I also really appreciate his focus on entry throughout the book, in terms of thinking about and making the case for championing the case for patents for small companies, for small inventors, without over romanticizing it. We'll get to my point number 7 there. But he's consistently interested in ensuring that we have robust competition. There is the ability to enter, and going back to the initial democratic nature of our patent system with low fees and examination, it wasn't about your relationships and who you knew and whether you had a relationship with the king. It was really about how good your ideas were. And I really also see his inclusiveness in thinking about, in his dedication to entry among writers as well. Where else are you going to see, Richard Epstein and Anjali Vats and everybody in between all cited in the footnotes and having conversations with each other. So, even if we're in different fields or sort of have different kind of trainings, he's bringing it all together for us. And again, I really appreciate that. And I also appreciate his elevation of women writers, Anjali Vats, Kara Swanson, and others, because I think he's reading broadly and he's including them in his discussion. I did also really appreciate what John had mentioned, the transaction cost of transaction capabilities discussion. I don't know if there was a Amartya Sen in that, but I really, having read his previous book and be familiar with how much he cares about thinking deeply about the philosophical and moral, underpinnings of patent law. I also thought that was a really brilliant focus point, and I hope he continues to work in that area. I do think that there's many transactions that, and this is my own quibble, because you're looking at patents and you're looking at litigation records and getting as much as you can in terms of the details, you're, naturally, as the rest of us, are missing a lot of what's actually happening in this transacting, right? And so I do think, as we know from Lisa Wallet's work, patents are being read, patents are being learned from, they're being traded, they're being used. And so I think this capabilities work is very rich, but I would challenge the kind of methods that you use to access that information. And maybe we can work together, but your survey work that you did earlier with Ted Sigelman, who I think is here as well, this is the landmark work on how startups were thinking about patents, I think really gave us a perspective. And I do think that work is very important. If we really do want to steward the patent system's transactional capabilities, we should do more of those types of methodological approaches to try to understand that. So finally, I want to also acknowledge that I thought was very novel. And what you're really doing here is, when you think about patents, again, we do have this Jeffersonian, you call it Jeffersonian inventor, it was kind of a small inventor, the basement inventor. We have this image in our mind of this independent inventor who really comes up with a new idea and is using the patent to kind of help them develop and then and cultivate their small business. And you say, well, that's, important theme, but there's a mythology behind it as well, because even in the beginning we were thinking about patents as really helping make the corporation, the knowledge flows within them and across them, more efficient, and the focus here really should be on that. So this, I think, is an homage to that idea. You've really helped us kind of think about corporate invention as a priority and helped us really focus on this area, which is harder, frankly, to get into because it's harder to access what's actually happening in corporations. So the intervention that I wanted to provide is with number 7, to think about inventors in corporate America, not just inventors or corporations, but inventors in corporate America. And a lot of work that I'm doing right now, which I'm going to show shortly, just a bit of it, I think tries to make this case. And I'll try to convince some people here that these are folks worth thinking about. And again, I think you referenced Catherine Fisk's work and others in thinking about this kind of relationship between the individual and the corporation. I mentioned that when I was working in the government earlier, we were talking, negotiating with China on this topic of whether or not there should be remuneration that is regulated for to go with patents, right? So as in Japan and some other places, you have the right as an inventor to get some remuneration tied to your invention, not just necessarily assign the rights immediately, but you could get some downstream royalties. And the issue for China was really that they have so many innovators that are in big companies that aren't innovating, that aren't doing anything because they have lifetime security and tenure. And the question is, well, how do you stimulate them to innovate and to put effort in? And I go back to, again, this first principle. What is the principle of the patent system? Is to spur, as John Duffy would say, or induce effort. And so I think that we've kind of thought about, well, in corporate America, why do we bother? It's not really that important because they have assigned their rights. They don't have a right to remuneration. So, essentially they're just doing their job. And I think, again, the work I've done, as well as others, to try to look more closely at what's happening in companies, in inventors themselves, is worthy. So I have an initiative called Diversity Pilots, started with Lisa Wallette, Margot Bagley, and others. We have a project. And what I want to do now, because I have this luxury of having all these amazing patent law people on the line here, is really to actually just take a minute to listen to a couple inventors. And these are corporate inventors talking about what becoming an inventor meant to them. So I'll just put this here. Hopefully everyone can read it. I'll read it out loud just in case people are like on their phones or other things. But this is from Chris R. He's a senior director of engineering. And we've done a lot of surveys, about 4,000 people, and we asked them about the number of questions. So one of them is about, what did becoming an inventor mean to you? So this person says, previous to our first invention being approved, my team had never really wanted to submit anything due to concerns about the possible negative impact that may result if it was not a success. With this first patent, we have put this concern behind us and are driving forward. The help and advice of the patent team has massively helped give us confidence in our abilities, as has the process they have developed. The team and myself believe we are seen and perceived as the go-to experts, and much of this could be attributed or linked to our first patent. So again, in these large corporations or even smaller ones, the signaling ability or the kind of credit that can come from a patent can be a motivator, can be an inducer of effort. I think these, again, I was just really surprised by these narratives. Again, this guy, Chris R., he has already a job as a senior director. He's obviously making very good money, but he still saw the patent itself as something that could show internal recognition and signal that there was that he was an authority, and that was important for his team. Another kind of answer we got was from Randy S. And he talked about the impact of the patent award on his family, right? He says, my family directly benefited from the patent award. They increased the down payment on my home. You know, he went on and talked about how this helped in his community and helped raise his confidence more generally. So I know that, Rod Shetty and his co-authors have written that if we had full participation in invention, we'd have 4 times more innovation. And I think that these types of narratives explain a little bit what those mechanisms are about, sort of being an inventor and being able to kind of use that as a spur to economic or social mobility. So Lisa Wallette and I actually have a piece coming out in Science tomorrow, but I was able to I think it just came out, which is called Improving Equity in Patent Inventorship. And this is about kind of focusing on inventorship law. So again, you talk about assignment law and its importance. I would say there's also, sort of another set of doctrines, which is maybe as a suggestion for the next project, to think about what's actually happening in inventors. And we make the case that if you actually broadened who you gave credit to, you would potentially, increase who was given credit beyond the kind of the strict standard for inventorship up to 75%. And we sort of have some different data that we brought upon to do that. So I'm not going to continue to promote my own work here, but I will say that I think that this work is, exemplary in so many ways. I think it's really helped us to think about how to do our own work, and I think challenges us. And again, because it is a series of what I showed earlier in terms of context, I'm looking forward to continuing to see future projects, and I'm just really appreciative of being able to talk about the work today. Thank you very much.
Thanks, Colleen. Thanks. All of the comments were really fantastic. Really appreciate all of the commentators with giving Rob's work the serious and rigorous read that you all gave to it, and and the comments have been fantastic. This is really going to advance, I think, the discussion significantly, and I think your comments really show just how rich and the breadth of what Rob's work is going to be leading to in both the academy and hopefully in policy and law as well.